Quick greetings. Welcome to video. Today, we want to discuss some basics about the concept of a trust. Okay, so that's what we're going to get to, hopefully. uh, I am, fresh off of recorded a video earlier today. And yeah, I'm kind of still in that mode. Um, so one thing I wanted to correct is Verrazzano is actually Italian. I think I may have referred to him as being French, but Verrazzano, when he saw Indians in the Roanoke who looked like Ethiopians but were not, there you have a African looking, they're not African, people that were not part of any slave trade. Okay. So there is the out for Indians who are starting to see what's going on here. And it's been in the works forever. So it's almost airtight. But when a liar is in the house, you're going to slowly start to realize the cracks in the narrative. The fact that there were treaties involved, that gets overlooked. Now, yes, as we always say, the treaties were bogus, but why would, okay, so they're going to say what those treaties were with the Native Americans. Okay. All righty there. All right. Um, hmm. Again, if you trace your Indian back before slaves, and like with the Roanoke, you're seeing that they predate slavery, as the Roanoke were quote unquote discovered by Verrazzano in the 1500s. So yeah, that clearly is making my Indians were there before Indian removal. That's making them come up not as any slaves of any civilized tribes, because the Roanoke were uncivilized Algonquins. And again, I want to stress 99.999% of Algonquins are still seen as uncivilized. That's why they're not talked about. You will hear their tribal name, but you won't hear what language that tribes spoke. So that's how they, uh, partly how they genocide and erase Algonquin presence. Again, we'll always say when they first arrive, the first thing you run into is Algonquins. Uh, Now, Verrazzano, he also went up to the Maine area. Like uh, I said before, something about Powhatans, but in actuality, uh, Verrazzano went all up and down the East Coast, uh, North Carolina, and I believe up to Maine. And so all of those Indians are looking like the Roanoke Indians. Okay. which means they resemble Ethiopians, even though they're so. What are we learning? We're learning that Indians who claim to be United States citizens are just speaking of their slavery. We all know, but now that the Lord and Master of the civilized Indians has spoken, uh, has confirmed that United States citizenship is for the babies of slaves. So Indians, I just have to keep stressing it because I don't believe these Indians heard it when we said it on this channel before. But now that their Lord and Master, Mr. Trump, has spoken, now they're starting to see where their what shall we say, their version of Moses was leading them. It was not the promised land. Their Moses Trump was leading them to Africa. So you keep following, you know, these foreigners, and they're going to make you foreign. Because this is something that apparently Indians just don't ever learn. And you are definitely talking about the Negro Indians who were doing all the windmilling for Donald Trump, right? Again, we're going to thank Mr. Donald Trump, for informing the misguided Indians, the misguided Negroes about, what their citizenship is all about. And that other Indian that has disappeared, I believe he was called the research guy. Yeah, that brother was again, it's just no denying it. I ain't saying nothing but the truth. If he should ever find out what I said what I said. And what I said is that brother was the biggest windmiller for Trump, yo. What I mean by that, he was practically daily making videos praising Donald Trump and look what Trump did and blah 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 blah. And maybe he'll get on here, appear again and have some other way to praise Trump from another angle. But we rest assured, your Lord and Savior Trump has really made it clear for you what you are, and you are what you are. Okay? And that is a descendant of a slave to the rhythm. Slave to the rhythm. Live in that rhythm. You slave to the rhythm. Yeah. Yeah. I'm just I can't even hide the the joy of clarity. What do you say to that? What do you say to that? It'll be another psyop if they do come out, from hiding all the prior quote unquote Negro Trump supporters who were trying to say they were Indians. No, you're not. Use a baby of a slave from Africa. Yeah, so this is the plot thickens. It's getting, we Indians that knew this for a while, but we just wasn't being heard. No one was trying to hear us. We just gonna sit back and eat our popcorn. Sit back, eat our popcorn, and see what these slaves gonna do now. You'll see what was happening now. They had your ancestral Africans come and meet with your Lord and Savior about organizing some stirring up some reparations for you Negroes that are the babies of slave. Yeah. I'm so glad your daddy is able to explain to you where babies come from, where the babies of slaves come from, who they are. Yep, 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 indeed. That's how them the cookies be crumbling. So now that we're narrowing down who the real Indians are, hint, hint, the Algonquins were never considered civilized. Hence, they are in none of the civilized tribes. They were not part of the Iroquois Confederacy. And again, the Lenni Lenape are just ultimately they were under some kind of domination by Iroquois, and they, had to go along to get along. And then next thing they adopted the Iroquois turtle. Yeah. And they didn't need I'll say this for the Lenni Lenape if they ever become Algonquin again. You never needed a turtle because you already had so much land. You already was fully grown. It was the Iroquois that needed a growing magical turtle so they can grow bigger, bigger, bigger because they were so damn small without colonizer daddy. And they always needed some kind of confederacy of Indians that did not speak their language. Maybe those Indians didn't know what the hell they were getting into. They were just, the Iroquois came, bopped them over the head and said, join our Iroquois Confederacy. They were the most warring confederacy. Yeah. And these were matrilineals, y'all. I know we all don't like when I say that, but I got to say, those Iroquois claiming that they was matrilineal. So that them some fighting ass witches, okay? Some fighting ass witches. Okay. I'm sorry, I got to say what I got to say. I'm sorry. I don't mean to affect nobody. But they're the ones claiming that they were so matrilineal, whereas the Algonquins they were also patrilineal. So they weren't just matrilineal. I guess you had more of a balance, shall we say, because Algonquins were not exclusively matrilineal. They had patrilineal. And when you have a patrilineal lineage, that means you're not going to be very uh, able to be penetrated by colonizers. You're going to be impenetrable in terms of just having a baby and they bang they're an Indian. No. Mm-mm. See, so you gonna need a patrilineal aspect at least both. I mean, I think maybe that's the ultimate sort of some kind of balance of both. And that's what Algonquins had, in terms of they are the only Indians that are being said to have patrilineal. Iroquois are strictly matrilineal. And so when the Moors came, all they had to do was penetrate the Iroquois, and boom, now your babies is from Mali. And you got your Lord and Savior Trump telling you that, yeah, y'all's is the slave babies and y'all became Indian by way of the Native Americans. That's their narrative. And now you're stuck with that until you get out and tell this beast that, wait a minute, before you came, I was Algonquin speaking. So somehow I allowed the Moors in my family to bring me to your mercy because the Moors is from where you from. Y'all both basically from Africa and Europe and Mongolia. So and it just you can imagine. I'm gonna add a more current way of looking at this. And I'm sorry, this is not to diss the females because ain't all females down with this. Ain't all American Indians females down with this. But you know, the apparently TikTok is hot with all the females that are gushing for European males. Again, yeah, that's how you became African. You were gushing over, oh, this his accent. And an Indian made a very important point, and I'm just going to repeat that point. You could practically condemn Caribbeans, the real Americans up in here. Somebody got to say it. These are first Americans. You know, I'm half Caribbean, right? So you hear a Caribbean with an accent, and you saying he's a foreigner. But when you hear a black Scotland, what do they call it? A black Scottish man, oh, talk to me some more, Shaka Zulu. I just love your accent. Y'all falling in love with the accent, and then you want to condemn Caribbeans and say they talk funny, they sound African, or you prefer your African with a Negropean accent? Okay, that's how you got misled, okay? They came with that sweet talking Mac Daddy BS, and then next thing your babies is foreign. And now you're trying to have your babies take over the real Americans' birthright. Nah, that day is over. No more Negropean babies of slaves. No. Mm-mm. But yeah, y'all all cushion for the now you know, that's some Indians saying, every European nation now want to show vomit up they black and have them come on to TikTok talking with these basically European accents. And now the American females is all, oh, whoa, tell me more. I just want to hear you talk. I'm sorry. That's what's on the damn internet. It's not me. This is what is being said, you know. So that's how America got taken down when the sweet talker pimp daddy from Negropean land come over here with his accent and his Bible and boom. you know, that's how it happened. I'm sorry. Now y'all got to stop falling for that. Stop falling for just somebody with an accent you never heard before. Because when you find out he's just as trifling as any other Negro, then then what? That accent gonna wear off real quick. and these Negro peas are just macking on that. You know, yes, I'm Scottish. Yes, who the hell cares? Why you come on the internet to tell us you a black Scottish? We don't get you want to try to get our shit? Is that what it is? You supposed to think that's appealing? And then another point, another uh I think it was Lady Boulay. I'll give her a shout out. She's been cooking lately. But she was saying, if you're all that, why are you in Scotland? Why y'all ain't in Africa where you belong? Because you ain't American, right? Uh, yeah, yeah. Y'all in everybody's country. And now you calling yourselves black while you in Scotland. No, you're Scottish. You're African Scottish. Come on, get over it. But you black. You want to put on your black face for American Indians so we could think it's cool to be black while you in Scotland and we being treated again, United States slaves are babies, citizens, and you over there with your sweet talking Scottish accent and your Italian. Well, the one that's I've seen that's Italian, he didn't talk. He there with his face hidden, and I'm a black Italian. Oh, whoopty doo. What you want? A black award? You want an American Black Award? A BAMI or whatever? A black Oh goodness. Come on, miss me with this. Y'all is Scottish and Italian. You ain't black. Do they call y'all black over there? Or do they have legislation calling you black? What do they call you in their legal work? Forget what you trying to wear a black mask. What do they call you in their legal paperwork? A citizen of Scotland? So you're Scottish, right? Or some shit. Or I don't know, Kenyan Scottish, whatever. You see how these Negroes operate? You see who's really taking our birthright? I told you, ain't no white man going to get up there talking about he's a black Scottish. So who's trying to be you, American Indians? Is it a white man? No, no. It's these Negroes that's in every European country because that's who their forefathers are, the original Negropeans of Europe. Again, Ben Franklin told us they was all swarthy. I believe Benjamin Franklin said it was only the Anglo-Saxons that were looking white. Okay, and that's why Britain ends up being the seat of this, I don't know, imagined kingdom. You know, um, yeah, that was given to Britain because those was the Anglo-Saxons. They appeared to be white. So that's why all the other European nations kind of bowed down and hid their blacks and until now, saving them for the awakening. Now they popping out of the woodworks, talking about they black. Y'all better do what Tyler did, even though she getting all kinds of red. She getting all kinds of cancer. But because she said, I ain't black, I'm colored. There's a difference. Oh, now she backtracked though, said, but I'm a black colored. Okay, look, little girl, let your handlers figure out what you are because they making you look real crazy up out in these streets. They making you look real crazy. You said you're colored. You said what you said. Don't say you black and colored. But I'm trying to say she had it right. She didn't want to be black. But colored, unfortunately, colored is another one of our misnomers. So that's not going to work either. But at least she knew she wasn't black. She's smarter than these black Scots under these streets. Getting online, talking this ignorance. You're a black Scottish. You're a fucking liar. That's what you are. You're a fucking liar. You ain't black over there. Why did they even say that? Why get online to say that now? Why? Do you want to be the recipient of black codes? Have at it, because this American Indian don't want it. You a black Scottish? Okay, we got some black codes over here. You want those too? Huh? Dummy. All grinning and skinning and looking like a over-educated fool. So just because you got a fucking accent. Fuck out of here with that foolishness. Showing how ignorant these continental quote unquote blacks are. How ignorant y'all are to get online and call yourselves black. What you want to be American? It's not good enough to have being in Scotland where you belong. You you claiming a black the lowest caste system title in America. That's what you want to be. And you dumber than us are, than we are. We're going to be talking about ebonics. You're dumber than us. Ah. So yeah, miss us with your BS. You're not black. Look in your codes and rules over there in Scotland and tell me if they call you black and if you're a slave. Are you a slave over there, Mr. Black Scottish? Where all this crap came from? With your damn King James? I'm the black Scottish. What the fuck you want? What kind of prize you gunning for? My land? It's over. Stay in Scotland. And tell the Scottish that you're black. Maybe they'll put you at the bottom of the caste system when you tell them that you want to be a caste system crayon box label. These European Africans is making us all look not just dumb but stupid. Not just crazy and ignorant, but stupid. So anyway, we were supposed to be talking a little bit about trust. So let's share our screen. So that awakened attorney, Peter Dorico. Y'all really need to get y'all a taste of some Peter Dorico. Y'all want to know the real deal, what y'all in when you a civilized Indian tribe. So Peter Dorico is going to break down to us um, some basics about a trust. So let's see what we can catch here. I've had to read this a couple of times to try to get a handle on this. We want to show how everything when it comes to Indians is, shall we say, it's not the norm of a, like, say what a normal trust is, what a normal citizen is. When it comes to American Indians, they create something new. They created for you a federal citizen. Before there were state citizens. Before 1868, there were state citizens. They were not bound to the public debt like a United States slave baby Indian citizen is. And that citizenship was created specifically for those who were seen as African slaves. Civil rights were just for African slaves as well. And civil rights were just a part of the Bill of Rights, as we always say. Okay, so let's start reading. So Peter Dorico is telling us about what happened with the Navajo Nation and how the trust was basically they were cheated. Now, again, these are the fake-ins, so the government can do anything they want with these technically. But we just want to learn what the basics of a trust. So let's read. The Navajo Nation, known as an Indian tribe, so they're in commerce automatically, right? Indian tribes in commerce. Article 1, Section 2, Clause 3, Indians would not be this type of Indian because they cannot be dominated by Congress because they're not represented in Congress. Okay. This was in Indian Country Today, a publication that Peter Dorico writes for or wrote for on the 15th of April, 2009. Okay, so he tells us on April 6th, the U.S. Supreme Court denied the Navajo Nation any compensation for government actions that allowed Peabody Coal, a corporation called Peabody Coal, to extract millions of tons of Navajo coal at low rates for 45 years. So they digging up these Navajos' land. These Navajo let these bastards on their land, and they digging up all the coal, right? Just take it out, take it away, roll it away, guys. For 45 years, millions of tons of coal. Okay, so when you're an Indian tribe that's in commerce or federally recognized or civilized, what you're saying is, do me, daddy, like you never did before. Do me, daddy, till I'm out on the floor begging you no more. Don't do it no more. So that's what you're doing. When you were federal, civilized means take whatever you want from me, daddy, and treat me like yesterday's hoe on Hooker's Point. Okay, that's what civilized mean in a colonizer world. Okay, you do better as an uncivilized Indian. Okay, so Peabody Coal extracted millions of tons. Do you have any idea what's in your land, American Indians? That this why this whole foreign entity is here in the first place? Talking about Africa got everything, then why ain't you over there? Oh, you took everything I'm over there? No, you didn't. Whatever we got going on over here is worth more to you because Africans run Africa. If Africa was all of that, you would see a government in Africa that looks like ours, a sea of Europeans, right? You get a picture of all the senators and House representatives in Congress. You think you in Europe, right? You never guessed that this country was filled with people that look like Ethiopians but were Americans. Okay, so Peabody Coal extracted millions of tons of coal from Navajo land, right? For 45 years at low rates, right? The decision raises deep issues about the meaning of continuing viability of what is known as the trust doctrine in federal Indian law. So, trust doctrine in federal Indian law is different from trust doctrine that is not Indian law. Once again, you're getting a jump off knockoff. When they give you a jump off knockoff, they created something new that's unconstitutional that allows them to do whatever they want to do because they created it, just like they created civilized tribes, just like they created civilized Iroquois. Okay, when they create you, they get to. I think of a rhyme, but it ain't coming. When they create you, they get to do whatever they want to do with you. Is the bottom line. You don't have a say. You're a brand new entity that's not mentioned in the Constitution. So I'm sorry, I got thrown here because he says the decision. I'm not sure what decision he's talking about a case, but he didn't mention the case, so we got to read more. Uh, but yeah, the U.S. Supreme Court, that's the big dictator of all civilized Indians. The Supreme Court make all your laws for you. Okay. So in that decision, okay, so it denied. That was what the decision did. It denied the Navajo Nation. I'm sorry, reading is fundamental, right? The Supreme Court decision denied the Navajo Nation any compensation for government actions that allowed Peabody Coal to extract millions of tons of Navajo coal at low rates for 45 years. So the decision was no, we're not going to pay you at any the right rate. So this decision raises deep issues about the meaning of continuing viability. Well, the doctrine of discovery has repudiated all this kind of shenanigans. So the Supreme Court would not be able to do this today unless Indians allow them to. Okay? So this is known as the trust doctrine in federal Indian law. So what is the first thing we learned about trust doctrine in this first paragraph alone? We learned that when this government is holding funds for you in a trust and they're supposed to pay you at a certain rate, they can lowball you. So these are the people that's holding your shit, right? Or supposed to pay you when you allow some corporation to come up and drill in your land and millions of tons of coal. And the person that's holding your trust said, well, we don't want them to pay you. And Peabody Coal don't have to pay you what the coal is worth. We could lowball your ass. Now get on out of here to get out of this court. Bang, bang. Court dismissed. And then Peabody Cole says, thank you so much, trust, what do you call it? Trustee. Thank you so much for ruling against these fools again. Thank you. When you become a civilized tribe, the Supreme Court gets to wipe their ass with you. Okay? That's what you are, a piece of toilet paper already used. Okay? You civilized Indians, and then you Indians that insist that you are United States citizens. Okay. Your slavery is sealed. So compared to me, you are a slave. You Indians that are civilized, compared to me, who ain't trying to be you, you are below me. Okay? And I hate to say it, you put yourself there when you run your big mouth and don't know what the hell you're talking about. Okay? So yes, you're part of the short bus too. Yes. The short bus crew. Yes. The original 1964 lease. So in 1964, the lease established a maximum royalty rate for the coal on these Navajo fake Indians' land. Okay. Okay. Did we hear that the Navajo is being deported too? Okay. So that's really why y'all didn't get the money you do. You got to be real Indians. I'm sorry. So I know y'all upset because you was in a trust with the devil. That the devil shouldn't even be having a trust for real Indians, but for fake Indians, yeah. So I'm sorry you got gypped, but that's what you do when you in bed with your foreign daddy, because you foreign too. Okay. So the original 1964 lease established a maximum royalty rate of 37.5 cents per ton of coal. And they took millions of tons, right? U.S. Department of Energy historical data show the average market price of coal of all kinds in 1963. Now, this is 1964. They're getting paid 37 cents, basically, $37.50. No, I'm sorry, 37 cents. Oops. No, it wasn't even dollars. Oops. No, I'm sorry. Let me correct that. 37.5 cents. Okay. But the rate in 1963 was $4.55. So the Navajo should have got, since this lease was established in 1964 with a rate of 37.5 cents, but in 1963, coal of all kinds was $4.55 per let me see what they tell us. Per ton, okay? Per ton. Thus, the original royalty rate was 8.24%, right? The rate was subject to reasonable adjustment by the Secretary of the Interior on the 20th anniversary of the lease and every 10 years thereafter. DOE data show that by 1984, this is 20 years later, the 37.5 cents per ton rate yielded 1 to 2% of gross proceeds, far less than the original 8.24%. So 37.5%, you're only getting 2% of the rate. I'm sorry, yeah, a rate of 2% when the original rate was 8.24%. Okay. In 1984, the area director of the Bureau of Indian Affairs, we know all about the BIA and how they work for the government too, right? Not for Indians. We decided that they should be called the Bureau of Colonizer Affairs to be more accurate, right? Because you handling things the way colonizers want it to be, not the way Indians want it to be, right? BIA, bitches in America. Pursuant to the presumed federal trust authority, raised the lease rate to 20%. Okay. Okay. Of gross proceeds as requested by the Navajo Nation. So they acted like they was doing something for the Navajo Nation. We got to raise it to 20% for now. Peabody filed the coal company that didn't want to pay 20%. Peabody filed an administrative appeal and requested the Secretary of the Interior to postpone the decision, it should be, or to rule in Peabody's favor. So don't decide now, or if you decide now, rule in my favor and not the Indians' favor. Thereafter, the Secretary and Peabody representatives met privately, but the Indians wasn't part of this, yo. The Navajo wasn't part of this. They really put the hole in Navajo for you that time, right? Thereafter, the Secretary and Peabody representatives met privately, and the Secretary postponed his decision, just like Peabody wanted. This is not what the Indians wanted, yo. First, they got the area director of the BIA, pursuant to presumed federal trust authority, raised the lease rate to 20% of gross proceeds. But Peabody didn't want to pay that, as we said, and they talked to the Secretary of the Interior and said, rule in our favor or just postpone this. Don't give these ratchet fakians no extra money. We paid them 37.5 cents. Okay, that was good enough. Okay. So they met in secrecy and they decided to postpone the decision of the area director, was it? The Navajo resumed negotiations with Peabody, and a rate of 12 to 0.5% was agreed. So they brought the 20% down to 12.5% was agreed. The secretary approved the amended rate. So the Navajo got cheated even after going to court, right? In 1993, now this is even later on, because what is this, the 84? Okay. So in 1993, the Navajo filed suit against the United States, the corporation, who's head of all of this, right? Alleging the secretary's actions constituted a breach of trust. You trustee, what's going on? United States, you the trustee, right? You made yourself the trustee. The Court of Federal Claims found the secretary had violated the most basic common law fiduciary duties owed to the Navajo Nation by acting in Peabody's best interest rather than those of the Navajos. That court nevertheless concluded the breach of trust did not require any compensation. Do you hear that, y'all? You see how they do civilized Indians? And you Muskogeans rushing to become citizens in the Muskogee Nation. This is what y'all gonna get, okay? Just a little preview, okay? When you gonna stand up and get your ass out of the system all the way? Or you think you can half step this beast and not be eaten up, swallowed up? You think that's not gonna happen because you black? It's gonna happen even quicker. These Navajo ain't even black. Look how they getting treated. So you think you're gonna become part of the Muskogee, the Cherokee, the Chickasaw, the Creek, the Choctaw, the the what's what? Seminole. Yeah, did we say that already? Y'all, you think y'all as babies or slaves, you think you're gonna get better treatment now that you a citizen? A citizen? Citizenship is for foreigners and babies of slaves. The foreigners got state citizenship. The baby slaves got federal citizenship. So they are under the District of Columbia only. Okay. District of Columbia is basically owned by Britain, unless they done sold it, past the hot potato. Somebody else get in trouble. But Anna has taught that it's always the principle, no matter who the corporation gets sold to, the principle is still the principle. Okay, UK? You okay, UK? I mean, it's nothing terrible. It just means the UK is the UK and America is America. And the two shall never meet again, because when they do, this odd genocide occurs and nobody knows where it's coming from. Isn't that weird, UK? Isn't that weird how that happens, though? Hmm. And now an American has become part of uh, the nobility of the UK. Yeah, I guess that's supposed to bring them as if the well we got a princess now? No, thank you. No, thank you. No, thank you. Mm-mm. The doctrine of discovery is repudiated. We don't do nobility over here. So that court nevertheless concluded the breach of trust did not require any compensation. It's a court, y'all. So the Court of Federal Claims, so it's a federal situation, right? Again, the federal is the owner of all things civilized, tribal, okay? So the court did find that the secretary violated the most basic common law fiduciary duties in trust law owed the Navajo Nation by acting in the Peabody's, the coal company's best interest and keeping their rates low rather than those of the Navajo. The court nevertheless concluded the breach of trust did not require any compensation. You got what you got, 37.5%, or we adjusted it to 12 point 5, what is it? Percent, but you ain't getting no 20%. The trust relationship necessary for our jurisdiction does not exist. Let's read that one more time. The court nevertheless concluded the breach of trust did not require any compensation because the trust relationship necessary for our jurisdiction does not exist. Um, that's a very interesting statement. The record of the case shows the entire leasing arrangement was premised on federal supervisory authority. The core of the so-called trust doctrine. Under this doctrine, the federal government asserts paramount ownership of, of paramount ownership of and power over Indian lands. So civilized Indians don't own any land. They just got a lot of fiat, but that is controlled by colonizers. When you have a lot of fiat and no land, consider yourself not wealthy because you're going to be paying rent to somebody and it's going to be high like it is right now. And even, even mortgages, even higher, or in some cases. So when you're the landowner, that cuts out you paying anybody rent or mortgage. And in fact, you are the one that is to collect rent from every foreign entity on their land for as long as they're there because they do not own the land. We don't sell Indian land because we don't have land to replace it. We got what we got, which is all of the Americas. So we sell some of that and we sell a little more and a little bit more, a little bit more. What are you going to do? Sell yourself into the ocean? So no, we don't sell land. No sovereign people, I don't believe they would ever sell land. I think the way to stay economically sound is that you would only rent or lease, meaning you're going to get paid for as long as that person is on your land and they're foreign and they call themselves doing business. Well, part of your profits or your business is going right to the landowner. Okay. So what does that mean, Indians? It means that everybody, every Tom, Dick, and Harry that comes here, no, they're not just going to become an Indian. If it's for business, they are not going to become an Indian because there'll be some kind of conflict of interest. So anything that comes here like a corporation, you're going to have to pay. Individuals are not necessarily corporation. So maybe they can become an Indian on an individual basis if they succeed in showing and proving that they are not trying to genocide us with their little foreign doctrines. Okay, maybe once you get through the vetting, you know, on an individual basis, yeah. And if you're not a corporation, if you're a corporate entity, baby, you're going to pay as long as you on this land. Hi, U.S. corporation, how you doing? You doing well because you don't have to pay nobody, right? You just collect like you the landowner, right? You hear that the doctrine of discovery was repudiated, and you running around here like a chicken without a head, trying to make everybody civilized tribes now, and trying to make everybody black by showing, promoting all this black Europeans online, black Scottish. We don't give a damn about no black Scot, not anybody who's not easily swooned by foolishness and a sweet accent. Not everybody drop their drawers for a nice sounding accent. Okay. Now there might be some hoes in this house that do that, but they do that for just have a nice voice and boom. Okay. The cookie jar right over there. To take as much as you like. Um, the record of the case shows the entire leasing arrangement was premised on federal supervisory authority, the core of the so-called trust doctrine. Under this doctrine, the federal government asserts paramount ownership of and power over Indian lands. The Peabody lease and rates were negotiated in this framework and only became valid after the secretary's approval. So it was the secretary, not the Navajo, you know, because the Navajo just sitting there having their shit run by a trust. Okay. Indian, a federal Indian trust. So Peabody gets to meet with the people representing or supposed to represent the Navajo's best interest. Peabody meets with them secretly without the Navajo, and they working out a deal. And that's supposed to be a trust relationship with these people that's supposed to be batting for the Navajo. They in bed with Peabody. Okay, you see how that went? Leaving aside for the moment the corruption of administrative process by the secretary's private meeting with Peabody, the question that arises from this case is, what does a federal trust relationship mean if it provides a presumption of authority over Indian nations, but carries no responsibility to them. So what he's saying is, if you're a trustee, how can you be the beneficiary at the same time? So when the federal government says they own Indians, then what's the point of Indians being Indians? If the federal government is basically, so that what I'm trying to say is the trustee is also the beneficiary. So there's a conflict of interest going on here. The Navajos is just window dressing. But when a real corporate deal takes place, the federal government, they take that they take they make the decisions. And what I'm reading this and I'm thinking what I think might have happened, maybe you'll cover it, but it sounds like Peabody may have gotten some kind of way where they paid the federal government directly and didn't pay the Navajo at all. And the federal government said, we'll just take it on the behalf of the Navajo. I don't know. But the Navajo didn't get anything, okay? They got shafted, okay? Just like the coal shafts that the Peabody drilled to take all their coal. So the real question that arises from this case, mind you, this is how all civilized tribes get treated, not just the Navajos. So this is the Cherokee, Chickasaw, Seminole, Choctaw, all and the Creek, all them. They agree to let their foreign daddy handle all their affairs. They're just there for window dressing. And they are Mongolian. And the real original civilized tribes went underground, and they're now black and promoting blackness. But they're the blacks that would get in the government seats because they're going to be the ones instructing all the uncivilized Algonquin Indians how black they are and how they are, got roots in Mali and Somalia and all of that. So what does a federal trust relationship mean if it provides a presumption of authority over Indian nations, but carries no responsibility to them? A trustee is someone, okay, let's listen, Indians, Indians who want their birthright. You other Indians, you just dealing with the fact that you slave babies, okay? A trustee is someone who holds property for the benefit of another. I want to stop there for a minute. Why is a trustee needed to hold property for another if that another is fully capable of doing that themselves? I'm stopping. I'm sorry. I'm going to stop. It's because they're looking at you that you're not fit. You're like, what do they call when in law when they call you a child? There's a word for that. But in other words, you're like a child and you need a guardian. So what those civilized Indians have to figure out is, how do we become made like children? Why can't we well, the first thing is you're not the real Indians. I'm sorry, I keep forgetting that huge point. So why is there a need for a trustee when a sovereign people are perfectly capable of handling their own property? Because it's property, right? A trustee is someone who holds property for the benefit of another. But do they need that? Who decided that we needed that? The doctrine of discovery made us that type of thing that needs a trustee. Okay. If the federal government pretends to control Indian lands as a trustee, how can it walk away from the fiduciary responsibility when Indian lands are exploited for corporate profit? So, in other words, how is the federal government not responsible when they allow a company like Peabody to ramrod the Indians that they are the trustees of? So you're going outside of the interest of the beneficiary to get in bed with the business that's ramrodding the beneficiary. You see how Indian trust work, y'all? You see how your trust is worked with when you federal? So he's asking, he's telling us a trustee is someone who holds property for the benefit of another. Sovereigns don't need somebody to do that, y'all. That's the first thing. But if you're a fakian, you can't handle that. See, I think there's a weird uh, legitimacy in this, in that the federal government is holding a trust, but the people that they're holding it for are not even the original Indians. So in a way, yeah, you don't get to have somebody else's property when the federal government created you in the first place. So you're not the real Indians anyway. It was all just so the federal government can have our land. That was it, y'all. You civilized tribes are just window dressing, y'all. And then y'all are window dressing, and then you got these Negro Indians that are just slave babies. So y'all just a bunch of losers, really. Just a bunch of foreigners and slaves. That's why y'all don't get the trust. But when real Indians step up, that trust is going to be dissolved. We don't need nobody handling our property, especially for colonizer. Okay. Um, the Peabody lease is not the first or only example of this problem, but the Navajo case brings to our minds a new realization that the trust doctrine is not a viable basis for preserving Indian nations. Well, those Indian nations are not the real Indian nations. So, unfortunately, this is what you get. Trusteeship responsibility in federal Indian law is often said to have begun with John Marshall. That's that judge, y'all, in the three foundational cases for federal Indian civilized tribes only. So let's read that again. Trustee responsibility in federal Indian law. See, it's not state, it's federal, y'all. Indians are a federal property. They're the slaves of the federal government, okay? That they charge with the debts that they rack up on purpose so that you can stay slaves. Trusteeship responsibility in federal Indian law is often said to have begun with John Marshall's suggestion in Cherokee Nation versus Georgia. You see how these Supreme Court cases are all part of this? But the doctrine of discovery said there shall be no more relying on the doctrine of discovery in these cases that John Marshall, or where John Marshall relied heavily on the doctrine of discovery. Okay, so the trusteeship responsibility, sorry, we're reading it again, in federal Indian law is often said to have begun with John Marshall's suggestion in Cherokee Nation versus Georgia in 1831. That the relation of the Indian tribes to the United States resembles that of a ward to his guardian. So they are so busy making these civilized Indians like their wards, just so they could be the guardian. But again, these civilized Indians are not Article 1, Section 2, Clause 3 Indians. They are Indians in commerce, and furthermore, they are created uh, by the federal government, point because they're federal Indian tribes. When you're civilized, you are federal. You become a federal Indian. Being civilized means you are now federal as well as Christian, if that helps you in any way, which it doesn't. Look how you're being treated. Now you got to remember these civilized tribes are basically the ones who became Christian. You know, that's part of what civilized being a civilized Indian means. You give up who you are as an Indian and you become a Negropean, or otherwise known as a Moor. So when you wonder, what did the Moors do when they came here to America? They made Americans Moors. And you still insist on being under Moorish tutelage. And they're tutoring you to operate in private as a consolation prize uh, that you get after you gave up your birthright. Interestingly, Moors can't take your birthright, but they can make sure that you're not here to claim it either. So they can't take your birthright. So what they give you is the option of operating in private, where you get to make a lot of money and don't have no land. You want to be in charge, Indians, not the recipient of some monopoly dollars. You want to, one thing you want to do is make the money, and then you control the money. But anything you get from a colonizer, you better make sure it's something that hits him hard, like gold, since he values gold so much. But did the gold come from this land? Because that was yours anyway. Because we don't need a trustee now that the Pope has repudiated the doctrine of discovery. But when y'all became Christians, y'all shouldn't have needed a trustee because you're civilized now. But as we see, being civilized means you become a whole slave for foreigners. That's what being civilized means. Okay? Cherokee. And I'm sorry to pick on you, Cherokee, but you're the most popular uh, Indian next to the Iroquois. And you are Iroquois speaking. But we gotta show you if you don't know to get out, we gotta show you what you are. You're a civilized Indian. Just by being called Cherokee, it just means civilized, basically. You gotta go back to being the Algonquin speaking Indians that you were. All of y'all. You can't be civilized no more. Do you get that? Or are you going to try to fight colonizer for what he created? You can't win in that fight. He created you. He Mr. Potato Headed you, like we used to say. Let's read that one more time. Trusteeship responsibility in federal Indian law is often said to have begun with John Marshall's suggestion in Cherokee Nation versus Georgia that the relation of the Indian tribes, this is what John Marshall said in Cherokee Nation versus Georgia, the relationship or the relation of Indian tribes to the United States resembles that of a ward to his guardian. So the United States is guarding you, and you're not getting paid going rate for all the coal that was taken from you with your guardian. With a guardian like that, who needs an evil, wicked stepmother? He's Mrs. Hannigan, and it's a hard knocks life. Annie, little orphan Annie. Who's giving you the hard knocks life, though? Okay, courts have given the government wide discretion as trustee. Wide. The Supreme Court said in Lone Wolf versus Hitchcock, 1903, we must presume that Congress acted in perfect good faith in the dealings with the Indians. Are you kidding? In United States versus Mitchell, 1980, the court came up with the notion that the trust relationship might be bare. In other words, all power and no responsibility. This is what happened in the Navajo case. So the United States gets to have all the power and no responsibility for how fucked up you might get under their guardianship. Oops. Oh well. Next case, bang bang. Court dismissed. You lose again, civilized Indians. Welcome to civilization, bitch. Oh boy. Many people, Indian and non-Indian, have failed to understand the evolution of the trust doctrine. They see it historically as federal protection against state governments. The states are not even involved, y'all. That's the funny thing. This is all Fed, y'all. Fed and corporations like Peabody. The state is just looking like them poor Indians. Damn, damn. But the states nowadays, this is a concept that's not too easy to explain. But what I'll try it again. It's a little complicated. But Anna, yes, I have to mention her, y'all, because she, along with this gentleman that we're reading his article here, they have been like, I don't know, lighthouses in guiding me to an understanding of this foul legal system. Yes, Anna von Reitz helped me to see the foulness. This attorney, Peter DeRico, who saw the wizard behind the curtain in his legal field of law, he saw the wizard, the United States government, the wizard behind the curtain. He saw what they did. He saw what they done did, right? And he called it out, risking, I guess, his esquireship, but he's a man about justice, right? Peter DeRico, he's a man about what's right, right? He don't care about no politics. He's looking at this as, is it even fair? Is it lawful? Forget about legal. Are y'all treating Indians the same way that you would treat even a corporation? Hell no. Because the Indians, these Indians are corporations, y'all. These tribes are corporations, okay, at the end of the day. But they're the ones that, uh, it's just all, it's just very, the whole thing is confusing because when you add to this mix that the Navajo is a corporation too, it's like, well, what y'all expect? I mean, it's just all commerce going on. Ain't no birthright Indians involved in this. That's why they can make all kinds of all ratchet trust laws or trust, you know, trustee laws, whatever. So many people, Indian and non-Indian, have failed to understand the evolution of the trust doctrine. They see it historically as federal protection against state governments. This view produces considerable tension when federal actions undercut the survival of Indian nations, as in the Navajo case. What he means is the Navajo, they can't even make a decent living on their own, what's said to be their own reservation land. They come get raped by Peabody, and the federal government says, "Well, what's the problem? This is how business do. You want more money, but I own you. I'll decide what you get." This is what the federal government is saying. It is time to see the trust doctrine for what it is, a relic of colonial thinking that allowed and allows the federal government to push aside states in the rush to control Indian lands. Hello, hello, push aside states. I love the way he said that. I love the way he said that. I want to read it again. It is time to see the doctrine, the trust doctrine, for what it is, a relic of colonial thinking that has been repudiated, by the way, that allowed the federal government to push aside states. Move, bitch, get out the way. In the rush to control Indian lands. The doctrine does not protect Indian nations from the federal government itself. Remember a long time I said, who protects us from you? You, the guardian, but who protects the Indians from the guardian? Opening sentence of the court's opinion denying relief to the Navajo, Justice Scalia refers to the Indian tribe known as the Navajo Nation. He said you a tribe masquerading as a nation. This is a linguistic move that displaces the external reality. The Navajo Nation, as indigenous people, originally free and independent of the United States, into a legal category, the category of Indian tribe. Ooh, we gotta read that again. In the opening sentence, they read you with in the first sentence. You little Navajo corporation, you. The court's opinion denying relief to the Navajo, Justice Scalia refers to the Indian tribe known as the Navajo. These court judges, man, they are truly little legal wizards, right? They know the words to say. You standing there thinking that it mean this, and they done patronize you, and you don't even know it. The Indian tribe known as Navajo Nation. This is a linguistic move that displaces the external reality. The Navajo Nation, an indigenous people, originally free and independent of the United States, into a legal category, the category of Indian tribe, presumably subject to the power of the United States. Oh boy. So here we're getting a little bit of the difference between a nation and a tribe, I guess. But when Indians run the show, tribe is the highest thing. But when colonizer is running the show, nation is the highest thing. So yeah, a tribe is subject to the power. That's what the Constitution is saying. Well, that's how they're interpreting the Commerce Clause. It says the federal government has the power to quote unquote regulate commerce among foreign nations, the several states, and with Indian tribes, with Indian tribes. So they're saying that a tribe is something they could dominate as well. Well, that's what he's showing us because I guess the word nation is not in the Constitution, but they took our tribes and made them a legal category. Well, we wouldn't have been that before colonization because we wouldn't have been in their legal system for them to have a category for us, point blank, period. So once colonizer is gone, all the words that we use can go back to being what we wanted them to mean. We were tribes, right? I say that maybe as a nation, it was all the different Indian tribes made up a nation. I'm thinking, but again, I really want to be careful with these colonizer words because we don't want colonizer to think we trying to rebuild his ratchet system. This linguistic move sets up the cognitive framework that makes the court's ultimate decision inevitable. You're subject to the power of the United States, civilized tribes. The bottom line is that the United States uses trust doctrine to control coal leasing on Navajo lands while refusing any fiduciary responsibility that is not specifically designated in some other law or statute. This is not a trust. It is analogous to the old royal prerogative. So they're saying the trust uh, that happens between the United States and federally recognized civilized tribes, it has to be specifically worded what their responsibility. And if it's not, they can do whatever the hell they want. So, of course, the law is very, like we said, right? He said it was, well, how did he put it? Wide. Courts have given the government, namely the Supreme Court, wide discretion as a trustee. So when the discretion is wide, that means down here that there doesn't it's nothing specifically designated. Uh, you know, they just have wide range control, yet if it's not something specified, they're gonna rule in not in favor of Indian tribes. And they're gonna use royal prerogative. What is that? The divine right of kings, right? So it's not a trust. It's just kings doing what they do, foreign kings and their little corporations doing what they do. The underlying historical and legal relationship between the Navajo Nation and the U.S. involves two distinct parties dealing with each other as separate nations. So the underlying historical and legal relationship between the Navajo Nation and the United States involves two distinct parties dealing with each other as separate nations. It is an international relationship negotiated and set forth in a treaty. There's a problem with this, ladies and gentlemen, and we're going to keep saying it till it makes sense. What they did with any Indian in the Americas, I should say, that they treated with, we have to know that the treaties were not necessary and they were only there to maybe pinpoint how you're going to be dominated. Why wasn't the treaty necessary for anyone in our little classroom? I hope you know the answer to that. Why was there no need for any treaty making with any Indian tribes by colonizer? Why didn't the colonizer need any treaties? The answer, if you guessed from previous videos, is because the doctrine of discovery took care of all of that. The doctrine of discovery says that if you find a foreign country whose inhabitants are not Christian, you can take over their land and make them your slaves. Is there a treaty needed in that kind of setup? No, the hell there isn't. You don't need a treaty when your baby daddy, Pope, told you you can take whatever you want. What was the treaty for? It wasn't necessary. I think it's because they had to try to sort of come off as if this was congenial. That's why I really I have to always say Indians, you would not have created this because this is all a product of the doctrine of discovery. This whole legal system is a product of the doctrine of discovery. And only the Moors in your family are telling you that we created this system because in fact, it was the Moors that ushered in this kind of system. How do we know this? What's another glaring example of how we know that this system is flawed? It's because the legal workers have titles of nobility from Britain, Esquire. So this legal system requires esquires. Now they don't like to call them that no more because it shows us exactly what they are. But if Indians created this, there would be no esquires involved. Lawyers are renamed esquires, which means they are a level of nobility in Britain. So that's a little key to let you know that this whole government, if the people representing the legal system are esquires, that means the legal system itself is British owned and operated. It has nothing to do with American Indians. Or shall we say it has nothing to do with pre-colonial. Would that work better for Indians? Okay. This legal system has nothing to do with pre-colonial American Indians. It is here as a result of the doctrine of discovery, not anything that any American Indian built. Also evidenced by the kind of trust relationship that this federal government created only with civilized tribes. So would Indians that are not colonized be called civilized? No. All of this legal stuff that we're reading, it only involves civilized tribes. Has nothing to do with uncivilized Indians. Okay. So the Navajo have now demonstrated the U.S. federal Indian law trustee system cannot protect the basic treaty relationship. It doesn't have to. It got the doctrine of discovery. That's what the judge, John Marshall, based his decisions on. It wasn't no treaty. He didn't base his decision on no damn treaty. He based his decision on the doctrine of discovery when he took land away from the Cherokee, who are civilized, Christianized, and all of that. It's what you get when you become a Christian citizen. Or shall we say, slave baby. The U.S. assertion of power without responsibility violates not only the treaty, but also a variety of international rights and norms. Well, we've never been on the international frontier as Americans. Only our doppelgangers that are federal creations, and they are barely there either. They're just getting dominated by not the international, they're getting dominated by the federal. They ain't even reached international yet. Because what their big daddy got his foot in that. So that is their representation on the international, the federal government. Okay? And all the atrocities that may be committed by this corporation is partly the responsibility of these civilized Indians. Y'all down with this. So you are partly responsible for all the international shenanigans that may go on with your daddy. It's a fucked up position, y'all. But we're peaceful Indians. We just talking from a perspective of our sovereignty when we talk like this. Okay? We are Article 1, Section 2, Clause 3 Indians, which means we have nothing to do with this federal system. We're not represented in Congress, not counted in the federal or state census, and we're not supposed to be taxed by any of these entities. I said something and I didn't complete my thought in another video and it stuck with me. But I was saying Indians are so not taxed or not supposed to be that when you go to that article about the 14th Amendment Indian tribes, which Indians should not be nowhere in any 14th Amendment because that's, again, for slaves. But that's what you agree to be when you became civilized tribes. Little did you know, right? Never trust your colonizer, if that helps. But anyway, in that article that we read, when one of the senators was asked so a senator asked Mr. Trumbull, in regards to Article 1, Section 2, Clause 3, who are the Indians not taxed by? Federal? That was the question one of the senators had. And Mr. Trumbull's answer was Article 1, Section 2, Clause 3, Indians not taxed, are not taxed by anybody. Point blank. Period. Not federal, not state, not corporations, no sales tax. Indians not taxed are not taxed by anybody. So that's what the Constitution said we were supposed to be. And that's what one of the senators, those were senators arguing that day. I think they said it took 3 days for them to argue how we can get Indians not taxed to be citizens who are taxed. But they did insist, most of them, that Indians are not supposed to be taxed. But where they went wrong is they kept saying that that was for Indian tribes. No, it's not. Indian tribes are civilized and federalized. So it most certainly does apply to federal Indians that they would be treated like citizens. It would not apply. See, that was a very interesting article. But again, they're misapplying the two different articles in the Constitution. So, but that's what the feds like to do. They want you to think that Article 1, Section 2, Clause 3 Indians are just like Indian tribes. They are not. Indian tribes are literally under the feds. Article 1, Section 2, Clause 3 Indians are not even represented in feds, period. They're not counted in census. Now you have a census and people are arguing, well, what do you Indians should be called in the federal census? We shouldn't be called anything because we're not supposed to be in the federal census because we're not counted by federal or state. So if we're not taxed by anybody, we shouldn't be on anybody's census. You see? We have our own. In fact, Indians are supposed to keep count of who's on their land. That's how a legitimate census would work with regards to American Indians. It would be us that would have to go into these states and say, we need to see, who's up in these states and what they about. We might not want them in this country. Yeah. So it is only ultimately American Indians who's supposed to keep a count of who's in that country, not a corporation. A corporation can count its employees, But a real quote unquote nation of people, they just gonna count any man and woman, whether they're a corporation or not. We're gonna be counted because we might have a threshold where there's too many people here. American Indians can say we don't want overpopulation. There'll never be an overpopulation problem if Indians is charged because we ain't trying to genocide ourselves, unlike some other entities on the land trying to genocide us. The U.S. assertion of power without responsibility violates not only the treaty, but also a variety of international rights and norms. Justice Scalia's statement, "This case is at an end," applies only to the system of federal Indian law. So all this is only federal Indians, not wild Indians, not uncivilized Indians like Algonquins. Again, we're going to say it again. There's no Algonquins in these civilized tribes, right? So who's the real Indian in the house? That'll be Algonquins. Those other ones are breakoffs of Algonquins that got tricked by the Moors. Originally, we all spoke Algonquin. The further back you go, you're going to find that it was Algonquin language of the woodlands and even beyond the woodlands. It was Algonquin language, even across the Mississippi or west of the Mississippi. It was Algonquin language. Again, a language doesn't travel that far unless it was older than the other language. That's why the Algonquins are so large, because they're the oldest of these quote unquote Indian tribes. The Algonquian tribes are older than other linguistic groups of Indians. That's why we all spoke Algonquin the further back you go. And once colonizers starts poking in on our land, all of a sudden we get Iroquois speaking, but they're speaking Iroquois and not writing it at some point. And that goes for all the other linguistics: Muskogean, Siouan, Tuscaroran, uh, Timucuan, all these other, particularly woodland tribes, are all younger than Algonquin tribes. That's why Algonquins are so big, y'all, because they were here longer. You know, that's how they got so wide and far. They proliferated. They were growing. That's why Iroquois are obsessed with a growing turtle. They're hoping to get as big as the Algonquin with their lies. Algonquins didn't have a turtle, a magical growing turtle. We didn't have a turtle at all. We didn't have to grow. We was already the big dog in the house. I'm sorry, that's what it was. But again, I'm saying we were all speaking Algonquin. So I'm not just trying to say, oh, I'm Algonquin, I'm better than. I'm saying if you go further back, you was Algonquin too. Yep, yep. Go back to our reading. This case is at an end applies only to the federal Indian law, system of federal Indian law. It does not bind the Navajo Nation from taking this case to international tribunal. You see, this is the thing. This is the thing. Now, Peter Dorico, he's given us his best, and I certainly appreciate it. But it's important for American Indians who are not the civilized ones to realize we don't have international friends. They're all in on it, y'all. They're all in on it. That's why we got these Black Scottish getting online. All of a sudden got to declare that they're Black. Why? So they're not our friend, y'all. They're not encouraging us to be Americans like they are Scottish. They want us to be Black. They trying to say what makes you like me is your Blackness. But you have a national identity and I don't. You better get out of my face, Negro. You better get out of my face with your bullshit. I'm not having it. I'm not having it. Do you know what you're even doing? looking crazy on these YouTube streets talking about you black and in Scotland. So you're Scottish, you dummy. But you'll be black for what? Somebody paying you to do this? You getting colonizer monopoly dollars? This is just unreal, y'all, how desperate they have to make us, how desperate they are to make us black. So no, no international tribunals. Why? Too many cooks in a damn kitchen. It's unnecessary. All we need is Indians who identify as Article 1, Section 2, Clause 3 Indians. That's what we need. We don't need nobody from no other foreign country. We can take care of our business. We're not children. We don't need guardians from other lands. Y'all got to get your shit right first before you give any judgments for India and all your other countries. What is your status in your country? We don't know that you're free persons in your country. So no, you can't. You won't be a peer of an American Indian. We need other Article 1, Section 2, Clause 3 Indians who know they're not supposed to be dominated by any foreigners. So an international tribunal, no. First of all the whole international construct, this whole United Nations, that was born in the United States. So they already created that. That's a creation of the federals, the feds. Yep. Woodrow Wilson, I believe. And then another president. Was it Roosevelt? I'm not recalling right now. But as we said in another video, the United Nations was the brainchild of a United States president. So it's the corporation creating some other jurisdiction. They hope Indians will run to that instead of running to their own land and getting a remedy there or making the remedy, because we don't get a remedy from the feds. We don't get remedy from colonizing. You got to know your standing and state what your remedy is. What is your remedy, American Indian? Your remedy is all the Americas originally belonged to American Indians. And we are owed compensation for from all foreigners on our land. That would include even the civilized tribes, because y'all are identifying as federal. So you might have to owe the real American Indians because you took part in disenfranchising you civilized tribes. You ran to colonize and said, we be federal Indians, but part of the deal is you got to make all the other Indians black. And that's what you did. And you're making us as if we're slaves. But you went underground and you got the poor Native Americans having to have the world imagine that a whole Negro was slave to a Mongolian. I can't even picture it, y'all. I can't, because I know these wasn't no Mongolians that had us as no damn indentures. It was other niggas that had us as indentures. These Mongolians can't handle a little. Come on, come on, come on. It had to be somebody that we trusted, y'all, for us to submit like that. It was Moors. It was Moors. The real Indians were indentures of Moors who took over your land and had you working for them. I mean, who out there can picture a whole field of quote unquote slaves working for Mongolians? I just can't even really fathom that image. I don't see it. I don't feel it. I look at Mongolians today and I just don't see how they dominate a whole Negro, or so-called Negro. We ain't there. I'm just saying. That's they see us as Negro. Um, I've never felt that energy from them. I don't see it. I don't feel it. I see it with a Moor. I see how a Moor will boss up on an American Indian. I can see that. I mean, you see it in the hood every day, right? I can easily see that. I can see uh, someone who looks like us having the ability to, with a lot of lies on deck, having the ability to manipulate us into a subservient position. It would have to be someone that looks like us. I'm just convinced of it. I'm just convinced of it. And they would have had the backing of the black nobility. And I think they they came off as nobility, the Moors. Um, so yeah, I'm sorry, we digress. So it does not bind the Navajo Nation from taking this case to international tribunals. But yeah, the Navajo can do that because they are foreigners too. But real American Indians, the ones that look like Ethiopians but are not, as seen eyewitness account by Verrazano de, I'm sorry, Giovanni de Verrazano in the 1500s. Indeed, the decision sets the stage for the Navajo to do this. That would be a good move. Yeah, maybe for the Navajo, not for American Indians, the real ones. Can federal Indian trust be trusted? This is another article by Dorico in this series. This was in Indian Country Today, the 22nd of April, 2009. The claim of a trust doctrine in relation to Native nations is the most widely cited concept in federal Indian law. It is also widely misunderstood, leading to confusion about the fundamental structure of U.S. Indian relations. The recent Supreme Court decision denying compensation to the Navajo Nation for decades of underpayment by Peabody Coal under federally approved leases is a case in point. The case started in the Court of Federal Claims, which found overwhelming evidence that the federal government violated the most basic common law fiduciary duties owed the Navajo Nation under principles of common law trust. Common law. However, the claims court concluded that the government's violation of trust was irrelevant because trust duties were not specifically stated in the coal leasing laws. Wow. They will find any way to get out of responsibility, right? The case went through extended appeals. The Court of Appeals for the federal circuit, it's the federal government dominating civilized Indians more than the states are. Now, the federal government can give authority to the states, but that still leaves the federal government as HNIC in charge, right? In charge. The Federal Court of Appeals for the Federal Circuit twice ruled for the Navajo Nation, reversing the claims court for failing to find specific duties, specific trust duties in the coal laws. The Supreme Court reversed the appeals court both times and agreed with the claims court, according to Justice Scalia in the latest decision. The case is at an end. I'm sorry, let's read that again. The case went through extended appeals. The Court of Appeals for the Federal Circuit ruled twice for the Navajo Nation. So it was the Supreme Court that reversed this court up here that ruled for the Navajo Nation twice. They got overruled by the Supreme Court, which reversed the Court of Appeals both times. So I want you to see how the Supreme Court messes over what they call Indians. Okay? Even when you win, the Supreme Court, basically you're going to lose. The guardian has arrived. The Supreme Court reversed the appeal courts both times and agreed with the claims court, according to Justice Scalia. So the claims court, I'm sorry, the claims court said that the violation was irrelevant. So the Supreme Court agrees with that the violations committed were irrelevant because trust duties were not specifically stated in the co-leasing laws. So the Supreme Court agreed with that. See, according to Justice Scalia. In the latest decision, the case is at an end. Bang, bang, court dismissed. The question arises, what does the federal Indian trust doctrine mean in comparison to ordinary trust law? The Court of Federal Claims suggested this comparison in its first decision in the case when it said, we find it useful first to measure the government's actions against the familiar standard of the common law of trust. But again, when you're handling your affairs, you don't even need a trust in common law, okay? That's what I'm trying to point out when I said common law. Indians don't need a trust. They can handle their own affairs. They don't need a guardian. You see? You only need a guardian if you're a colonized people and the colonizers taking over your affairs. Please make note of that next time you hear about a trust. So, even if it's in common law, it's not needed. Trust involves three elements. Let's get this. Property that is subject to the trust, a trustee who administers the property, and a beneficiary in whose interest the trustee acts. So the trustee is supposed to act in the interest, in this case, of the civilized Indian. But they're not. I remember somewhere in operating in private, someone said you don't want to be the beneficiary. I remember hearing this. I can't remember exactly where, but they had finessed this so good that they made it like it's better for you to be, what did they say you should be? I just remember there's something about you don't want to be the benefit, something like that. And so they was doing some swindling here. But anyway, the beneficiary in whose interest the trustee acts. A trust creates a relationship between a fiduciary, one in whom faith or trust is placed. I think that's what they were saying. You should be the fiduciary and not the beneficiary, because the fiduciary can take advantage. I think that's what it was. If I'm misremembering, my bad. But I do specifically hearing somebody say something about you don't want to be the beneficiary. And I think that's because they know that even in private, operating in private, the beneficiary is going to get shafted. That's the only thing I can conclude, you know? A trust creates a relationship between a fiduciary, one in whom faith or trust is placed, who controls the property. You see, an Indian can control their own land, okay? They don't need a trustee. And another who is the ultimate owner of the property. That would be the American Indians. We are the ultimate owner, but we don't need someone to be a middleman. We just have to get Indians that we trust to pass down our property to our offspring. That's all. We don't need an outside foreigner to do that. Because that's what the United States is really. It's foreign. This relationship may be defined in a specific document, such as a will, or by certain general principles, such as when an adult has care of a child, which is known as the guardian ward relation. Okay, they keep, see that child thing, it really is a perfect analogy for how they are sunning at least the civilizing. See, they can't do this with real Indians. So they created like a straw man for real Indians called civilized Indians. And they are wearing that poor straw man out, trying to make real Indians think that that's how it's supposed to be. But notice they're doing it only to civilized tribes. I don't know what the point of being civilized is. I really don't. Don't you want to own and operate your own shit? Guardian ward relation. That word ward is really troubling too. How are you going to make something that's called an Indian as if he's a ward when this is his land? Because those are not real Indians. Ordinary trust law is rooted in centuries of common law decision. Again, even in common law, Indians don't need a trustee. Okay? That is something that they would handle as a tribe. And it would just naturally go to other Indians. Okay. Now, if you were a foreigner who became an Indian, then you'd be included. But what we have is a foreign entity that's looking to exclude real Indians and take what belongs to us and give it to their chosen uh, beneficiary. And they want to make American Indians African. See, that's how you take the birthright. And everything that belongs to them, you holding it, hoarding it, and just giving it to anyone you want to give it to, who don't even have to be an Indian at all. And if it's a corporation, oh, whoop-de-doo, they really going to get the royal treatment. A corporation is. They're going to be able to extract coal and pay Indians like a pittance. So who's the real money going to? So that means there's some kind of incentive going on. Because if you are Peabody and Indians are asking you to pay them right, and their quote unquote guardian is saying, no, it's okay to pay them wrong, what is that guardian getting from Peabody? Or what deal did they make with Peabody to make it okay for Peabody to not pay those who are pretending to be Indians? Well, again, that's the big problem, that these are not real Indians. So they're not entitled to anything really but a one-way ticket back to Mongolia and Siberia, Spain, or wherever. Ordinary trust law is rooted in centuries of common law decisions about fiduciary responsibility in a broad range of situations. The law is almost poetic in describing the high standards of the fiduciary responsibility in a situation of trust. It has been said the duties of a trustee are the highest known to the law. Benjamin Cardozo, the famous Chief Justice of the Court of Appeals of New York, wrote that a trustee is held to something stricter than the morals of the marketplace. He further said that not honesty alone, but an honor, most sensitive, is the standard of behavior. On that basis, Justice Cardozo pointed out there has developed a tradition that is unbending and inveterate. I had to look that up, thinking it meant unmovable or something, unchanging. A high level of conduct for fiduciaries will not consciously be lowered by any judgment of this court. That was in Meinhard versus 1928. You see, Indians, we have to stop being swayed by the cases that go well. Okay. I think we got to understand that, first of all, do these courts have jurisdiction when we are not represented in Congress, when we are not to be paid taxes for representatives to the representatives, and we're not uh, uh, counted in their censuses? So that's the first thing. These cases, what they got to do with us when we're outside of the jurisdiction of the courts? That's the first thing. Don't get happy with a little happy joy judgment, because you got to remember they far and few between when it comes to anything known as an Indian in this system. On that basis, okay, we read that already. So it's a high level of conduct for fiduciaries, and it will not be consciously lowered by any judgment. So they have a high standard that they're not going to lower. That was in Meinhard versus Salmon, 1928. We can now understand why the Court of Federal Claims said of the Navajo case, were this a court of equitable jurisdiction? Considering a private trust, plaintiffs might easily qualify for remedies typically afforded wronged beneficiaries. It said if this were a case of equitable jurisdiction, so it's not a court of equitable jurisdiction, okay, considering a private trust, plaintiffs might easily qualify for remedies typically afforded wronged beneficiaries. The fact that the court denied relief for the Navajo Nation says that the federal Indian trust doctrine is not a true trust. So the trust that you hear that the federal government has, first of all, it's only, if we go with the narrative, it's only for civilized Indians. And look what they're dealing with. So, yeah, that is something that I guess we have to dig deeper. But I think it should be obvious. The knee-jerk answer is yes, whatever the federal court is holding actually belongs to real Indians. And that's why they get very nitpicky with these fake Indians, because they know they shouldn't even be giving it to them. But they like having the power of not having Article 1, Section 2, Clause 3 Indians to deal with. The trust doctrine started in 1831, when Chief Justice John Marshall, I'm trying to tell y'all how important that Supreme Court case was. The foundational Supreme Court cases as ruled or judged or decided by John Marshall. So he started this trust doctrine. John Marshall. It started in a Supreme Court by Judge John Marshall. So your laws are coming straight from the Supreme Court based on the doctrine of discovery that the Supreme Court Justice John Marshall relied on. So it has nothing to do with federal law. In reality, it has more to do with the doctrine of discovery if Judge John Marshall is relying on the doctrine of discovery. The trust doctrine started in 1831 when Chief Justice John Marshall compared the relationship between the U.S. and the native nations to that of a ward to his guardian. That was Cherokee Nation versus Georgia. Since the guardian-ward relation is a form of trust law, Marshall's suggestion became the federal Indian trust doctrine. Indian lands are the trust property. So Indian land are the trust property. So our land is being held in this trust, right? The federal government is the trustee, and the Indians are the beneficiaries, the ones who are supposed to benefit from their land. Or they never intend for you to benefit. There is no specific trust document in federal Indian trust doctrine. Ooh, he just pointed that out. There is no document. It's just that this Judge John Marshall saying it's like a ward to a guardian. So he didn't base that on any document. But wait a minute. He's going to tell us what it's based on. Notice there is no specific trust document in federal Indian trust doctrine. I'm sorry, there is no specific trust document in federal Indian trust doctrine. This means that for the trust to exist, it must be premised on general legal principles. The principle on which Marshall based his analogy was Christian title and supremacy. That is the doctrine of discovery. Let's read it again. The principle on which Marshall based his analogy was Christian title and supremacy, a unique aspect of colonialism and not a general principle of trust law. So the trust doctrine is based on the doctrine of discovery, Christian doctrine of discovery. The federal Indian trust doctrine differs from ordinary trust law in another profound way. An ordinary trust is subject to judicial supervision, and the court and trustee are independent from each other. In federal Indian law, the courts have created both the trust and the trustee. So there's a conflict of interest, y'all, that favors the trustee. The trustee created the trust. It wasn't an Indian that created the trust and asked the trustee to, supervise it. The government created itself as the trustee is what he's trying to tell us. So let's read this again. The federal Indian trust doctrine differs from ordinary trust law in another profound way. An ordinary trustee is subject to judicial supervision, and the court and trustee are independent from each other. So he's trying to say the court is the trustee in Indian federal Indian law. But in real life, it would be the court would be separate from the trustee. So the federal government is the court and the federal government is the trustee, is what he's saying to us. Where again, in common trust, the court would be separate from the trustee. They would be two different entities. So there would be a level of equitableness or equity. Here, the court is the trustee. Decisions that benefit not the beneficiary, but the trustee itself and those that are in bed with, like the Peabody Corporation, the coal mining corporation. They met without the Indians there, we read. So they had a sort of a backdoor deal going on between themselves. Let's figure out how we're going to, not pay these Navajos. So the courts have created both the trust and the trustee. The decision in the Navajo coal case demonstrates how far federal Indian trust doctrine is from ordinary trust law. The claims court acknowledged that in enacting the coal leasing law, the United States assumed the responsibility to manage minerals, such as coal, in a fiduciary capacity. However, the court said the general trust relationship in itself does not impose such duties as are erected in a complete trust with fully accountable fiduciary obligations. The court concluded under the general or bare trust relationship in relation to Indians, fiduciary obligations applicable to private trustees are not imposed on the United States. So the United States, they're saying, is not the same as a private. They're not operating in private. The United States is basically operating in public. So in other words, that's their argument why the United States don't have the same responsibility as a private trustee does. The bare trust is a new twist on the emperor has no clothes. The U.S. creates a trust for Indian lands, making itself trustee, subject to its own supervision based on a religious supremacy notion. That's the doctrine of discovery that Peter DeRico is telling us that they are relying on. Religious supremacy. That's the doctrine of discovery. Gave them that religious supremacy. It then takes steps to control the property of the beneficiary, including enacting a law for coal leasing on Indian lands. When the supposed beneficiary, the Navajo Nation, challenges the acts of the trustee says there is only a general and unenforceable trust, a bare trust, and no specific trust obligation. I just get to dominate you just any way I want to regarding the coal leasing. To rub salt into the wound, the trustee, that is the United States, says the lack of fiduciary responsibility benefits the beneficiary. So their lack of responsibility is somehow benefiting the Navajo Nation by forcing the beneficiary to fend for itself, to fend for itself in the name of self-determination. Oh my God, this is nuts. Ooh, the feds are looking like a big, uh, ignorant bully. Just says anything. Make up anything. Remember, this is not based on any document. It's something that the judge said, and they ran with it based on the Christian doctrine, right? Christian doctrine of supremacy. That's that is the doctrine of discovery, y'all. It was the Christian doctrine of discovery. So these folks think they're acting in a Christian manner. So your Christ must be a whole demon. So to rub salt into the wound, the trustee, which is the United States, says the lack of our responsibility, it benefits you. Help me to help you to get rooked. Help me help you by fending for yourself in the name of self-determination. So you fending for yourself by going to court. Yeah, I'm fending, but you're gonna make me lose. So how is that benefiting me? I was losing, not getting paid what I'm due. But how's that benefiting me though? It seems like it's benefiting Peabody, the corporation. Well, y'all all corporation, including the Navajo Nation. Unfortunately, that's why I think y'all getting this treatment because y'all ain't the real deal. Okay. Implicated in every instance is the delicate balance struck between exercising fiduciary responsibilities and respecting tribal sovereignty and self-determination. The trustee, the United States, has created powers to control Indian lands by means of a trust doctrine that cannot be supervised by ordinary trust principles. The Navajo case stands for the proposition that the U.S. trustee only has trust responsibilities if and when it says it has trust responsibilities. That is no trust. It is a ripoff and a fraud. Okay, so I don't think we're going to need the next article. We might save that for another reading because we've gone a while now, and I just want to get a basic handle on all of this, and I hope this helps. I do want to um, chart actually. So let me see. Trust structure. Well, here they're talking about a grantor, a beneficiary, and a trustee. So that's in a typical trust, but this is not a typical trust because as Peter DeRico showed us, these two are one and the same. I believe that's what he's saying. Or maybe actually, this might not be it. Let's look at this chart. It's a little hard to break it down because he's saying that what the United States has is not typical, right? So this is typical, and what the United States has is not typical. They everything when it comes to Indian is compromised and bended and shaped so that the Indians get dominated coming and going based on what? The doctrine of discovery. So I think protector can be sort of like a guardian, right? So that's the United States is assuming this role. The settler, that would have had to be an Indian, I guess. And we don't have that. We don't have any Article 1, Section 2, Clause 3 Indians involved. In fact, we don't have any uncivilized Indians involved. So the trustee, so the government is, I think, the guardian and the trustee or something we could might say, and the beneficiaries. They're not, well, these Fakians are being made or put in the position of beneficiaries, but maybe that's part of the reason why they're not getting anything because they're not the real beneficiaries. So we just want to look at the little charts, even though I don't know if they fully apply. This one seems a little simpler. Grantor. So one way to look at this trust structure with three main parties is who was the grantor? And okay, so this is a better way than what I first said. The grantor was actually the Church of Rome. who granted the trustee the authority. An Indian was not involved. So here's the real American Indians here. They're not getting anything, but we never needed a grantor and we never needed a trustee. That's how we have to look at this. There is no need for a trust when the Indians are alive and well and they're not children under a guardian unless we are under colonization. But because the doctrine of discovery has repudiated colonization as we know it, we don't need this setup. It could all just go right back to Indians and they just control all of their land or get, no, they still will be controlling it, but they will get compensation for those commercial entities that are on the land. And that was, a lot of corporations would just run off of the land. They would like, okay, we out now. Once the Indians need payment, I don't think we're going to get a sweetheart deal since we've been basically raping them. So anyway, so we looked at that. But what I thought we might look at quickly too is the repudiation of the doctrine of discovery. But again, I'm in that situation where I have this drop down menu that doesn't go away. Okay. You know what? Do I want to do this instead? Let's quickly look at this. What did the doctrine of discovery say? Now, I did a video on this, but I guess I'm superseding that video. I didn't post it. The doctrine of discovery was a concept initially sanctioned by the Catholic Church through papal bulls in the 15th century that provided a framework to justify the colonization and seizure of lands in the Americas. So it's our land that's being held in this trust, right? In the Americas, Africa, Asia, Australia, and New Zealand. It asserted that Christian European monarchs had the right to claim and exploit territories inhabited by non-Christians and to dominate indigenous peoples found here. This is what the judge, John Marshall, is relying on. The doctrine essentially stated that discovery grants title. So whoever, quote unquote, discovers your land, they get title. A European nation that discovered territory previously unknown to other Europeans acquired title to that land against other European powers. So initially that was Spain that got this. Then Britain came with her greedy ass. Ultimate title reside, not, it's not the people of Britain, mind you. Okay, let's be clear. It's not really the people of entity of these foreign nations. It's the leaders that are in bed with these monarchs and with the Church of Rome, happy that the Church of Rome allowed them to come and rape America. Ultimate title resides with the discovering nation. Indigenous peoples were considered to have only a right of occupancy. And that's what one of the cases said, right? We just occupy the land. We don't own it because it was taken from us because of the doctrine of discovery. So we only had a right of occupancy and did not hold the ultimate title or right of territorial domination. This ultimate title ultimately passed to the United States after the American Revolution. So what they're saying here is after they broke away from Britain, they proceeded to make themselves like our little Britain, and they dominated the Indians. Now, so the Britain dominated the colonists, then the colonists turn around and dominate the Indians after we helped them break free from Britain. How shitty a deal can you get, right? Justification for colonization and exploitation. The doctrine's underlying ideology supported the dehumanization, dispossession, murder, and forced assimilation of indigenous people. Forced assimilation. as well as a claim to their resources. Okay? Key aspects. Papal bulls. The doctrine's foundational elements can be traced to a series of papal bulls, including Romanus Pontifex in 1455 and Inter Cetera in 1493, which granted Portuguese and Spanish monarchs the right to invade and subjugate non-Christian lands and people. Legal precedent. In the U.S., the doctrine of discovery became part of federal law through the Supreme Court case. So the Supreme Court spearheaded federal law. It came through the Supreme Court cases. The John Marshall trilogy. Judge John Marshall is the one that's creating all this bullcrap based on the doctrine of discovery. What are we reading about the doctrine of discovery? Sole legal precedent. In the U.S., the doctrine of discovery became part of federal law through the Supreme Court case Johnson versus McIntosh in 1823, which denied indigenous peoples right to own land based on the principle of discovery. So that right there is telling you the Supreme Court is using the doctrine of discovery to dominate Indians. But the doctrine of discovery has been repudiated. So you tell me, American Indians, what does that mean for this kind of shenanigans? It should come to an end, right? Well, you have to make it come to an end. You have to stand up and say, number one, you're an Article 1, Section 2, Clause 3 Indian because you're not supposed to be taxed. You're not supposed to be represented in Congress, and you're not supposed to be counted in any censuses, federal or state. On top of that, these cases that sort of gave the United States this idea that they can dominate even Indians not taxed, that has been repudiated. All of that has been repudiated. Everything they built this house of cards on has been retracted by and repudiated by the Church of Rome. Thank you, Pope Francis, who repudiated this doctrine of discovery. Impact on indigenous peoples. This doctrine had a devastating and enduring impact on indigenous people worldwide, including the seizure of their lands. Once again, it's all about our lands, right? Algonquins had the most land in the Americas. In North America, particularly, Algonquins had the most land. Now you don't even hear about them, right? How does colonizer meet the person that has all the land and end up in bed with the Indians that had the least land, the Iroquois Confederacy? Iroquois Confederacy like a small dot in the middle of Algonquin land. Just like they just dropped out of the sky, right? No, they didn't. They are just compromised Algonquins. That's why they're in the middle of Algonquin, right? Look at where Iroquois Confederacy is placed, and that will tell you who was dominating where Iroquois lived. Iroquois would have had to been like on the outskirts of Algonquin land to really show that they were like Iroquois would have to be like in California, I would say, where you know the map doesn't the colonizers' current maps don't really show a great Algonquin presence. But when you have the Iroquois literally surrounded by Algonquins, that tells you that Algonquins had all of that land. And the Iroquois are they just had another ideology that made them Iroquois. And we called them that because we knew that they were different. They were snakes to us. But we named them Iroquois because they were starting to, come up with the Moorish ideas. And they apparently became strictly a matrilineal thing. But what I was gonna say, it reminds me of the story in Yaqub, where in the story of Yaqub, what brings the need for the creation of the Caucasian is that among the lands of a dark-skinned people, 30% of those people were called dissatisfied, while 70% were satisfied. I look at the 70% as Algonquins. And then that small 30% in the Islamic world or the American version of Islam, this 30% now sets out to create another type of race of what they call white people. And in the book of Yaqub, as I said many times now, this white man created by the 30% dissatisfied blacks is to bring 97% of American quote unquote Negroes to their doom. This is the book of Yaqub, y'all. Yaqub, father of mankind. Yaqub was seen as a black man who was part of a 30% of dissatisfied Negroes that became a matrilineal type of thing. And they decided that they're going to enter into the dog fight, what they call a white man. So they're going to use the white man to basically genocide 97% of American so-called Negroes. It's right there. Secretariat 82, I think, is the page where they tell us about this 30 what was it they tell us about? Yeah, that the white race was here to uh basically genocide 97% of American Negroes. So where do we know white men to come from? Originally, Europe, right? So when we have the book of Yaqub telling us that a white man was created, where was the Negroes that created them? They had to be nearby, right? In close proximity to the white man, who Europe was given to by these Moors. I'm trying to say that these are disgruntled Moors who want a quote unquote white man to take out Americans, according to the book of Yaqub, Father of Mankind. Secretariat 81 or 82 is the page. Secretary, they call it Secretariat. Okay. So yeah, it's seizure of our lands, forced removals, cultural suppression, violence in the name of their deity, and the disruption of our societies. Recent developments. Repudiation by the Vatican. In 2023, the Vatican formally repudiated the doctrine of discovery, stating that the papal bulls did not adequately reflect the dignity and rights of indigenous peoples, and that the doctrine was not part of the Catholic faith. Calls for action. Indigenous advocates and international bodies. We don't need international bodies. We just need a few good American Indians. That's all we need, y'all. So, uh, indigenous advocates continue to work to dismantle the doctrine's legal structures. And what's that? The entire legal structure in the United States, of the United States, is the what is what is the doctrine's legal structure? It's right here in America. It's called the United States, y'all. But we are peaceful Indians. Remember, we're relying on this, not our fist, right? We're not trying to uh you know come up against some big beast that is controlling the mercenary militia, because we got the law on our side, because the doctrine of discovery was repudiated in 2023, March 30th to be exact. Repudiation. So indigenous advocates and international bodies. We don't really want international bodies because those international bodies, if they come and rescue us, they're going to say, "Well, what about us now? Can we get a piece of this?" And that's when we go right back to the beast, right? International, not necessary. We don't need a foreign daddy, y'all. I know it seems like, oh, just let's turn to the international stage. Help us. That's not what they're there for, y'all. That's not what they're there for. They're here to buttress the United States corporation when they seek to dominate other countries. That's what this is all about. Okay. How could you go to an international stage when your local stage is so fucked up? If you can't fix your local situation, I highly doubt and know for a fact that you ain't trying to fix no international ones. You're just, again, avoiding responsibility, right? Guardian, trustee, just avoiding responsibility. Blame it on the international people. Yeah, well, you created the international. Once you got on our land, then you went what you call global with it. He said, help us dominate these Negroes. So they continue to work to dismantle the doctrines, legal structures. Dismantle. So you civilized Indians are not helping in that goal. So dismantle the doctrines, legal structures, and policies and advocate for indigenous rights and self-determination. Um, I mean, we just got to make sure it's American Indians doing that for American Indians. If we get help from anything that's seeking to become our new daddy, we're going to have problems. So we read that, right? And that did talk about John Marshall case, right? All of them were doctrine of discovery based. But we want to make sure. We asked the question, did John Marshall rely on the doctrine of discovery in his rulings? It's up here. We asked it. The answer was AI overview we're looking at. Yes, Judge John Marshall, I'm going to call him a judge because he was a judge, relied on the doctrine of discovery in his Supreme Court rulings regarding Indian tribes, particularly in the case of Johnson versus McIntosh, 1823. This decision established a legal framework that prioritized European and later American claims to land over, let's say United States claims, because this don't make no sense. This decision established a legal framework that prioritized European and later United States claims to land over those American Indians based on the principle that discovery, doctrine of discovery, by a European power granted title to the land. All you have to do is show up and boom, you had title to all of American Indians' land. But the Pope said no more, no more. Elaboration. Johnson versus McIntosh, 1823. This landmark case centered on a dispute over land ownership between individuals who had purchased land from Native American tribes and those who had obtained title through a U.S. government grant. Okay? So the Indians didn't own the land, they were just occupying it. It was the federal government acting as a trustee that actually owned. So how can you be a trustee if our property is yours? It's just your property, right? We don't factor in. It's your property and you do what you want to do. So that's not really a trust, a legitimate trust, although they want to say that they hold our lands in trust. No, you hold our lands hostage from us and you get paid for it, right? And you use it any way you want. You got these foreign moguls growing this genetically modified food. So you're not the best guardian because you sure ain't guarding our food. You just, oh my God, it's just, anyway, doctrine of discovery. Marshall's opinion in Johnson versus McIntosh. They keep quoting this case, but they all was bad, all three of them, invoked the doctrine of discovery. So the answer to that question, this John Marshall that we keep reading about, Marshall's opinion in Johnson versus McIntosh invoked the doctrine of discovery. So there you have it. Did the doctrine of discovery influence United States laws regarding particularly federal Indians? But if they can grab any Indian, they will grab you too. If you don't say you're an Article 1, Section 2, Clause 3 Indian. So, yes, John Marshall's opinion in Johnson versus McIntosh, as well as the other two cases, because it's called the Marshall Trilogy, foundational cases, invoked the doctrine of discovery, which had its roots in European international law. Ha ha. Wait a minute, did y'all hear that? The doctrine of discovery has its roots in European international law. So can international law really help us? No, because the doctrine of discovery has its roots in European international law. To assert that European nations, upon discovery of lands previously unknown to them, gained ultimate title to that land. Diminished rights of indigenous people. The doctrine of discovery, the doctrine, as interpreted by Marshall, effectively diminished the rights of Native American tribes to their ancestral lands, recognizing their right of occupancy, but asserting that the discovering nation, in this case the United States, held ultimate title and the right to regulate land transactions. So they're not just regulating commerce, they're regulating land transactions. Further cases. The principles established in Johnson versus McIntosh were further developed into subsequent cases, the same John Marshall cases, these are the other two, Cherokee Nation versus Georgia in 1831 and Worcester versus Georgia in 1832, solidifying the legal framework that favored the U.S. government's claims over those American Indian tribes or Native American tribes because they turned Native American. Consequences. The application of the doctrine of discovery in these cases had profound and lasting consequences for Native American tribes, impacting their land rights, sovereignty, and relationship with the U.S. government. So, American Indians do not own land. That's the first case, 1823. Marshall based the decision on the doctrine of discovery, referring to the way colonial powers laid claim to newly discovered land. So when you ask, did those first three John Marshall cases rely on something other than United States corporations, code rules and regulations? Yes, they went outside of the law of this it's not really the law of the land, but the laws of this corporation, and relied on a church doctrine in a system that says there's a separation of church and state, right? But for Indian tribes, they're not in states, so I guess that's another way they get around that separation of church and state. It didn't say separation of church and tribes, right? So the states are good for now until we create U.S. citizens and hijack the state citizens. But yeah, so they just find ways to dominate us, y'all. So we want to make sure. So we're making sure, yes, did the three foundational cases in federal Indian law rely on the doctrine of discovery? They certainly did. And they created the foundation of how all cases look at Indians in relation to the federal government. So we want to confirm Has the doctrine of discovery been repudiated? Well, we read in the last one that it was, but let's read more. Yes, the Vatican has formally repudiated the doctrine of discovery. This repudiation was announced on March 30th, 2023. The doctrine of discovery, based on 15th century papal documents, was used to justify the seizure of indigenous lands during colonial times. The Vatican statement declared that the doctrine is not part of the Catholic faith and does not reflect the equal dignity and rights of indigenous people. So, what I'm trying to get at is, if this was all built on the doctrine of discovery, if we stand up as American Indians Not Taxed, we can dismantle this based on the repudiation of this doctrine of discovery that built this house of cards, or that was built, or this house of cards was built upon, I should say. Several other Christian denominations have also repudiated the doctrine of discovery, including the Unitarian Universalist Association, the Episcopal Church, and the United Church of Christ. Once the mother church, which is the Catholic Church, repudiated, all the babies really will follow suit anyway, or they should. And these are just three examples, or one, two, three, three examples of the babies of that Catholic Church. The Vatican's repudiation is significant because the doctrine of discovery has been cited in various legal and political contexts, including by the U.S. Supreme Court for centuries. The repudiation is seen as a step towards acknowledging the harm caused to indigenous peoples by the doctrine's application. However, some indigenous leaders and organizations have called for further action, such as reparations and concrete steps to dismantle the doctrine's ongoing effects. Excuse me. So now I'm yawning, and so we're going to quickly look at the repudiation for just two parts. We're not going to read the whole repudiation, but this is it. This is the document on May 30th, right here, of 2023, from Pope Francis, who maybe I can say, you know, may he find mercy in light of his repudiating this horrid demonic doctrine of discovery. May he be rewarded as highly as he can be for what he did. So we're going to go down. You could read the whole thing at another date, but we want to go down to where it really drives the point home. And that's at section 7 and 8. This is the repudiation of this dastardly doctrine of discovery that these Supreme Court and federal government relied so heavily upon to seize our lands and hold it in a trust when we are here and fully capable of owning our own land and controlling it without need of a trust. Excuse me, without need of a trust. So let's read. In no uncertain terms, the church's magisterium upholds the respect due to every human being. The Catholic Church, therefore, repudiates those concepts that fail to recognize the inherent human rights of indigenous peoples, including what has become known as the legal and political doctrine of discovery. Legal. This has legal weight, y'all. As we see, it was the foundation of federal Indian law in this country. The whole entire government is here as a result of the doctrine of discovery. Article 8, or Section 8. Numerous and repeated statements by the church and the popes uphold the rights of indigenous peoples. For example, in the 1537 Bull Sublimis Deus, Pope Paul III wrote, "We define and declare that the said Indians and all other people who may later be discovered by Christians are by no means to be deprived of their liberty or the possession of their property." We call it our ancestral land because property is a commercial term. But we'll take it for now. And then when we get our land back, we name it whatever we want. We make the rules. And we are compensated for anyone who's still here squatting on our land. So this is a very important part. So Pope Francis is quoting Pope Paul III, who wrote, "We define and declare that the said Indians and all other people who may later be discovered by Christians are by no means to be deprived of their liberty. I prefer the word freedom, or the possession of their property. I prefer the words ancestral lands, even though they be outside the Christian faith." So being a Christian never stopped them from continuing to steal our land from us. Okay. In turn, you get a nice, beautiful mansion in heaven, but not on earth, while other foreigners squat on your land and don't have to pay anybody but the feds and any corporation that fancies that they own our land that they stole from us. So the Pope is saying you can't do that no more. So I'm sorry, we keep stopping. You can even be outside the Christian faith now. We can go back to being the happy heathens we were. And that they may and should freely, the key word here is freely, y'all. Get with the freely, okay? And legitimately, this is what I'm trying to tell these agencies of the feds, that I do my land freely and legitimately and enjoy our freedom, but they say liberty, and possession of our property. Nor should they be in any way enslaved, in any way. This is great because it kind of eradicates that thing in the Constitution that says involuntary, because they in the Constitution, I believe it was the Constitution that says we shall not be subject to involuntary slavery or something like that. So that means if you voluntarily make yourself a slave, well, we like that. You could do that. You could be our slave for free. We do encourage that. But the Pope is saying, in any way, voluntary or involuntary, to be enslaved, because he realizes all this was done involuntarily. And should the contrary happen, which means if an agency like the what do you call it, Department of Finance or Department of Environmental Protection, if they insist that I owe them taxes, they should if if they're in contradiction of me having my land freely, they shall be null. Okay, so should the contrary happen by any federal agencies or anybody, it shall be null and have no effect. So your ability to tax me is null and has no effect. In other words, it's not legal on that. It will be null, have no effect. Because what? My land is mine again. All I have to do is claim it and say what I need to say, as we saw in that case where when we looked at it, Judge Marshall was saying, unless express words of exclusion. So that means if you don't express your words of being excluded from taxation, we're going to go right ahead and tax that ass like we've been doing and we intend on continuing doing even after our big daddy, the Pope, said we shouldn't be doing this no more. We're going to keep doing it until you Indians say not to do it, because we don't listen to our daddy. We don't listen to God. We don't listen to our daddy. Do right, because you Indians have not said it, so that means you okay with it. if you don't say nothing about what the Pope said, that means basically you okay. And the Pope knew that too. I think the Pope knows that if we don't grab this, he washed his hands clean. If you don't do anything about this and you want to be a United States citizen, so happy with your citizenship, which comes with being an African slave, go on, knock yourself out, fool. Go on, knock yourself out. Got to be a fool. That's what Sanchez used to call you. Uh, so yeah, I think we've gotten through what we wanted to get through the basics. Uh, this is the attorney Peter Dorico's book. Oh, sorry, the cover is there. Now, don't like I said before, don't mind the picture. That is not a legitimate Mongolian, and that's what the feds have put in place of us. But so this is Peter Dorico's book where he tells us that federal Indian law is actual federal anti-Indian law. Author Peter Dorico here. Let's see. Let's show a picture of him. There he is. I've written to this man and I explained to him, about the misclassified Indians. And I just had this feeling like I really would actually like to meet this person to talk more. Uh, just hash this. He wrote those articles that we read just now about the Navajo Indians. He wrote that. Okay, Peter Dorico. Here he is again, one of his web pages. Oh, uh, to get into it, you could just put your email, and then you'll get his little newsletters or whatever, e-newsletters. Indigenous Peoples Issues, A Lens into Reality. I'm Peter Dorico. I've been involved with Indigenous peoples' legal issues for more than 50 years, beginning in 1968. Fresh out of Yale Law School as a legal services attorney with the Denibe, oh gosh, the Navajo Legal Services Project. So he was specifically, dealing with the Navajo. I taught legal studies for more than 30 years at the University of Massachusetts, Amherst, during the whole time. I represented and consulted with Native clients in state and federal litigation. These experiences taught me to view America from outside, or the United States from outside, to see what it calls federal Indian law is actually federal anti-Indian law, a law of domination. My book, Federal Anti-Indian Law, The Legal Entrapment of Indigenous Peoples, published September 2022 by Prager, grew out of this work. There's the book. If you want to read a bit more, introduction. Globally, Native peoples and their lands are at the bleeding edge of extractive violence carried out by the corporate state system in the name of progress and economic development, chasing fantasies of infinite growth like the Iroquois turtle and profit. John Trudell emphasized that we're all in this together when he spoke in 2001 at the Women's Building, San Francisco. What it means to be a human being. Every one of us is a descendant of a tribe. Every person in this room is a descendant of a tribe at some point in our ancestral evolution. So in our collective genetic ancestral memory, we had the experience of encountering the tech and no logic. Oh, wow. Perceptual reality. Whatever happened to the Indians here, trust me, it happened to the tribes of Europe. I guess that would be true because the Moors had them, under subjugation until they broke free. But basically, the Moors used them to come here and represent the Moors. But it's the Moors that's behind all this. I offer my writings as a tool in what Muskogee Creek up civilized medicine teacher Philip Deere called a proper education, a rightful education. So, review of my book in choice, a publication of the Association of College and Research Libraries, March 2023. This work is a tour de force, provocative and overflowing with insights, examples, and thoughtful interpretations, summing up highly recommended advanced undergraduates through faculty and practitioners. Review in these times. Peter DeRico exposes the capriciousness and hostility with which the United States uses the law to apply or deny justice to the original peoples of this land. There he is again. Uh, so yeah, I think on that note, uh, we'll read this and then we'll just call it a day. Okay, federal anti-Indian law, the legal entrapment of indigenous people. Telling the crucial understudy stories of the U.S. legal doctrines that underpin the dispossession and domination of indigenous peoples, this book enhances global indigenous movements for self-determination. In this wide-ranging historical study of federal Indian law, the field of U.S. law related to Native peoples, attorney and educator Peter DeRico argues that the U.S. government's assertion of absolute prerogative and unlimited authority over Native peoples and their lands is actually a suspension of law. A lot of Indians call this stuff law, like they're not going by the law, or they don't have law. This is all conquest. This is the doctrine of discovery in action. It is not law. It is a suspension of law. Combining a deep theoretical analysis of the law with a historical examination of its roots in Christian civilization, DeRico presents a close reading of foundational legal cases. Those three cases, those foundational John Marshall cases in the Supreme Court, where they basically made law when they said we are like wards with a guardian. The United States being the guardian, the trustee, the Lord, the master, the savior, all of that. God Almighty, all of that. That's what the this beast has fancies itself. Everything but foreign, right? I think they actually think they're somehow American too. Something is up. It's real crazy, you know. Um, his close reading of foundational legal cases, the John Marshall trilogy of cases, the three cases, and raises the possibility of revoking the doctrine of domination. Well, it's going to take American Indians to do that to its completion. We're the only ones who can. No one can be our savior. And, to do it, but it takes Indians. I think part of it was their Lord and Master Trump letting them know that the United States citizenship that they love so much, they love it because they are loving up on their past slavery, coming to this beautiful country as African slaves. That's your United States citizenship. I can't stress it more. I just want that to really hit home for those Indians that were they were like cheerleaders for Trump. Rah, rah, rah. Trump did this today. Trump did that today. Trump did this today. Trump did that today. Trump did this today. Trump did that today. Anybody remember the research guy? When Trump got elected, I remember his thumbnail picture, his face got bigger. It's like he did a super zoom close up to show us how happy African descendant of slaves he was that Trump came on the scene. Is his channel still up? What's he doing? Research guy, where'd you go? Where you at? I just want to know what you feel about being now that your Lord and Master told you what you really are. How you feel about that though? What's your feeling on it? What's your read on that? Now, I admit he had a lot of nice, quick little videos, but when he started going on his thump a Trump, 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 oh, it was like, and so many Indians were doing that, man. They were riding Trump, yo. They were riding good. They were getting good and gushy, gushy, good, good, good. And then he told y'all what you are to him. And I was silence. Silence. Some of them might come out of hiding and in defiance and say, I still love Trump. I don't care what you say. He just having a bad day. I still love my quads. I still love my quad. I still love my quad Trump. Even Candace Owens is like, ah. Even Candace Owens is like, ah. ah. So now how the tables have turned. There was Indians that, thought Candace was out of her mind, right? And now Candace done seen some of the light. And it's just funny because I just feel so vindicated. And so y'all keep following Trump, and he's like got the Pied Piper pipe, and all the little African slaves follow him to the boat. The Pied Piper leading y'all out with the Black Plague, and just go on, get on the boat in Africa. Swing low, sweet chariot, come forth to carry me home to Africa. Swing low, sweet chariot, come forth to carry me home. Oh, just keep swimming. Till we get back to Africa to be with the African men and women. Oh boy. So yes, I'm just so y'all know how I feel right now. I know you know. uh, let's finish reading this. Combining a deep theoretical analysis of the law with a historical examination of its roots in Christian civilization, DeRico presents a close reading of the foundational legal cases and raises the possibility of revoking the doctrine of domination. The book's larger context is the increasing frequency of indigenous conflicts with nation states around the world as ecological crisis caused by industrial extraction impinge drastically on indigenous peoples' existence. DeRico rethinks the role of law in the global order imagining and indigenous nomos of the earth, an order arising from peoples and places rather than the existing hegemony of states. We're going to stop the share because it's about time to close this out. Thank you for watching. I hope this helps to make the understanding of trust question the necessity of an Indian trust, and see the difference between what they call common law trust and federal Indian trust. In federal Indian trust, the federal government is the trustee and the grantor, or the supervisor, which is a conflict of interest when it comes to the role of the beneficiary. But again, Indians don't need a guardian. We took care of ourselves before colonizer got here, and we certainly don't need him now, especially when all you're doing is racking up a killing, living free on our land like a freeloader, and had the nerve to call us Indian givers. Are you just Negropean takers? Is one of the questions we asked a while back. But once again, thank you for watching. Till next time, be and stay only American so-called Indians. Thank you, ancestors.